The deadline for public comment on the controversial spy bill is tomorrow. That's the 15th of February. Now, the highly criticized bill will see the surveillance of electronic and communication signals and internet traffic on a very large scale. This means that normal South Africans who are not suspected of a crime or a threat to national security may be under surveillance. Another fear, of course, is that the bill could establish a surveillance state operating out of the office of the Presidency. Lots to unpack and also understand in this discussion. And to do that, we are joined by Freedom of Religion South Africa's Executive Director, Michael Swain. They, of course, have taken issue with the bill that sees the closing of a public comment tomorrow. Michael, a good morning to you. Thank you so much for joining us. I don't want to take for granted just how technical things can get here. Once you start talking about technology, surveillance and intelligence, you run the risk of having people not understand what we're talking about, particularly when it's something that really impacts them directly. I mean, your understanding of how the General Intelligence Laws Amendment Bill can impact the everyday South African.
Yes, thank you, Marie. Thank you so much for having me on the show. And you're absolutely right. It's important that we discuss this because this bill will fundamentally change the relationship between the state and its citizens, because clearly the state has a role and the citizens have a role. There's a democracy that we live in. And I think the biggest challenge is that it is important that although government may well have good reasons as to why they want to obviously protect the nation from potential threats, the powers of those who are tasked with protecting national security should be clearly and narrowly defined so that it doesn't infringe on the constitutional rights of citizens, and therefore it should also therefore be subject to proper oversight and accountability. But these are elements that are unfortunately very lacking in this particular bill. And so we believe in constructive solutions. So 4SA is really going to be putting forward our proposed definitions, because that's really where the problem lies.
Yeah, what I found quite interesting was really the intention behind even proposing the bill from the very beginning, right? So if we go all the way back to 2021, you've got the South African Constitutional Court having found that state security agency, through the way the intelligence agency was conducting bulk interception, was unlawful. And so there was the reasoning for us to have this bill so that there is the legislation to support it and ensure that it happens without causing abuse. But it seems that there's still very much issues around the constitutionality of the bill, even though the bill has been proposed within the confines of the Constitution in government's view.
Well, you're absolutely correct. And, of course, this is why we are concerned, because even though there may have been a good intention, you have to even look back at when they originally brought out this bill. The first version of this bill specifically was looking to target churches and religious organizations and NGOs. And as soon as you see that, of course, obviously, because Freedom of Religion South Africa, that's what we stand for, that particular constitutional right. Of course, your immediate antenna goes up. And it was then removed and redrafted. But again, the redrafting of the bill doesn't give any further comfort. All it actually has done is effectively it's extended the net even wider. It doesn't actually in any way limit, which we think it should, who the state is able to investigate, particularly because it is a very wide net that's opened and it's very invasive what can happen thereafter.
I go back to July 2021 for this one, and I think what we've done since July 2021 is certainly talk about whether or not the state had sufficient intelligence to see the sort of communications, if at all, that led to the massive riots that we saw, that cost us 50 billion rand. Could legislation like this assist in dealing with that sort of mass crime? And I say crime because in a lot of spaces that is what we saw in the future, though.
Well, again, there's the old adage, which is that, government never allows a good crisis to go to waste. And one of the problems, of course, can be that although there's obviously great and legitimate concerns about having that type of horrific, as you said, almost devastation that took place, it again is a question of how do you respond to it and whether you, in fact, overreact to it. Because again, the challenge here isn't so much the government doesn't have a good job to do, and it does. It has an internal security issues that it needs to identify and to deal with, and it obviously has an external threat. But the question is, how invasive is that going to be? And what is it actually going to do? How is it defined? Because, as you know, again, the devil is often in the definitions. And this bill, in its current format, literally represents the death of any meaningful right to privacy. It is a totally invasive process. And I think it's important that we actually understand just how invasive this process is going to be, potentially.
Have you responded as an organization to the calls for public comment?
Yes, we have. And we're also encouraging every South African citizen to get involved, because the opportunity to participate publicly means that we can make submissions. We have a website, which is forsa.org.za, and then you can click a button, you can download a template, you can see some of our concerns, you can modify that, it gives you the email address, and there's also an online platform through which you can make submissions. And yes, we are absolutely encouraging people to engage, because, as I said, this bill is going to change the entire relationship between church and the state and its citizens. You know, let's maybe have a quick look at what it's going to consist of.
Right.
If you're found to be a threat to national security, then they can look at any relevant data that they want. And that will include your financial records, medical records, any electronic communications, think emails, WhatsApp, Facebook, Zoom, phone call recordings. Everything will basically be able to be pulled up and investigated. And this investigation, unlike, for example, when the state or the police do fraud investigations, they don't have to get any form of permission. There's no court oversight, and there is no scrutiny by the courts. It can be carried out in secret. You may never even know that you're being investigated. And then the question comes, well, what happens if you fail the test? And the answer is, presumably, you will not be able to operate within South Africa anymore if you're operating within South Africa. So the definitions are the key things.
Yeah.
Let me give you who is actually caught in this net,
right,
because I think that's maybe the most germane thing. It will potentially make you available for vetting any person or institution that the state considers to be of a national security interest. But then that is defined as any threat, potential threat, any opportunity, potential opportunity. And this will include, for example, subversion. But subversion will be, for example, things that may exert undue influence on government's processes and policies and the sovereignty of the state. Does that mean that if you criticize the government's bills or policies, like we're doing on television right now, that you're potentially open to vetting? And it includes activities that are inconsistent with the principles set out in Section 198 of our Constitution. But these are very vague. You know, they include things like South Africa's resolve to live as equals, to live in peace and harmony, to be free from fear, and to seek a better life. I mean, that could be just about anything. And, of course, the threat to national security, as I said, is defined so broadly. So, essentially, the way that it is currently phrased, it means that literally anyone, any organization, for almost any reason, can actually be caught in this net. And once you're in that net, everything about your life, your business, which would normally be protected, some level of privacy, will be simply removed.
I know that your line is getting a little bit difficult there, but I really want to squeeze one in. And you of course, have touched on your concern that once the National Communications Centre, as it's going to be called once it is set up, targets or decides that perhaps, Michael, yourself need to be looked into, that they would not need to go through the courts for permission. But my understanding, though, is that it says that the surveillance centre would need to seek permission from a retired judge, right? So again, not going to the courts, but going to a retired judge, assisted by 2 interception experts before conducting that bulk interception. And we can talk a little bit about whether or not that's enough. And I imagine that you're saying no. But why was it important for the religious community to speak out? Because this is what I think really stood out for me, that you also found it to be an argument for religious freedom in the country.
Yes, because obviously, and again, these laws, when they come into force, they are in force and enforceable until they're challenged or overturned or changed. And what this gives the opportunity to do is that it gives the opportunity to potentially target any religious organization. And often religious organizations, by the way, have spoken out against what government is doing. We just have to look back at figures who we absolutely esteem, like Archbishop Desmond Tutu, for example. And this type of surveillance could potentially be pushed upon anybody who is taking such a view, or an organization, and potentially shut down. Now, we have the right to religious freedom. That means that we have the right to associate, to assemble, to express our views, to live them out. And this potentially could be used to shut that down in a very serious and concerning way. And we just simply don't believe that the way that it's drafted, as I say, is so broad and so wide. The protections are not adequate. The opportunity for accountability and for oversight is very, very vague. And so what we're saying, and our principal objection to this, is that the way that this bill is written, it's potentially going to be there, and it could be open to abuse. And that is not something that we think is at all a good idea, particularly not in a democracy. I mean, we are a democracy. And this type of law, interestingly enough, I think I mentioned in our press release that the U.S. House of Representatives have just looking to put forward a bill to challenge the relationship. And one of the things that they mention is that they believe that South Africa is facilitating the Chinese Communist export of its model of digitally aided authoritarian governance underpinned by cyber controls, social monitoring, propaganda and surveillance. And I'm quoting from that bill. The fact that this has got international interest and concern expressed about how invasive this could possibly be is obviously concerning. Okay.
Well, we are out of time, and I imagine that after these public comment submissions have been all submitted, perhaps we'll have another chat in the future. But thank you so much for your time. We really, really do appreciate it. That the Executive Director for Freedom of Religion, Michael Swain, is